also tend to be very vicious. Let me take the quorum. Just a moment, please. So the quorum is that it's Mr. Shitama for the state, Ms. Kaloni. Do you appear with Mr. Mbubi?
Yes, I do.
Oh, Ms. Magoma, allow me to record you on my proceedings. Sorry, 1 minute. Two matters to be so listed on the court list. Let's start with the hearing and then proceed. The public versus Feisal Mohamed Ali and Mohammed Hassan Konton. The application filed as a notice of motion seeks custodial orders. The accused were arraigned before the court on August 27, 2025, but the respondent's advocate at the time, Mr. Bupia, asked for time to peruse the application which had just been served with him. Mr. Fulama for the prosecution appearing virtually asked the court to defer the hearing of the notice of motion to be on August 28, 2025, when he would physically be in court. Thus, by mutual consensus, the matter was deferred to August 28, 2025. The respondents at this time are represented by Ms. Kavani, while Mr. Fulama and Mr. Chisama appear for the applicant. The application is routine and it seeks custodial orders. The fact that it is a routine application in no way diminishes the fact that it seeks to curtail the fundamental right, that is the right to liberty. That is just one limb of the prayers made to this court. The other prayer is for forensic extraction. But the prayer that attracts the most heat is the custodial request. The notice of motion dated August 27, 2025 seeks the following prayers. A, that this honorable court be pleased to issue extended custodial orders authorizing the detention of the respondent's hearing for a further period of 10 days, pending the completion of investigation into the serious economic crimes and that of dealing with wildlife trophies. Specifically, rhino homes, contrary to section 92.2 and 92.4 of the Wildlife Conservation and Management Act, Cap 376 of the laws of Kenya. B, that the Honorable Court makes an order authorizing the investigating officer KWS 8658, Proper Anthony Bao, to forensically examine electronic gadgets to reach a technophone, IMEs are listed, Infinix phone, IMEs listed, with ICCD numbers. That the Honorable Court make any other order that it deems fit. The application relies on the supporting affidavit sworn by Corporal Anthony Bao on August 27, 2025, and the grounds in the notice of motion. It is brought under Articles 49(1) F and G of the Constitution and Section 36A of the Criminal Procedure Code. Both Mr. Mulama and Ms. Kadoni submitted at length, and I thank them for their diligence as well as the authorities applied to courts. It indeed raises the level of advocacy as well as litigation when opposing sides come to court prepared, with well thought out and reasoned arguments as well as authorities to support their arguments. What follows next is a précis of the arguments made for and against the detention, which is the main contentious issue, an analysis of the case, and finally the court's decision. Neither party dwelt at length on the prayer for forensic examination of the gadgets. Mr. Mulama made his points around these arguments. On the first point, he relied on the Palermo Convention, for which the official title is the United Nations Convention Against Transnational Organized Crime. Incidentally, Kenya acceded to this convention on June 16, 2004. On the second point, he argued that the intelligence information gathered is to be presented to the court as evidence. The state is also liaising with other agencies, including Interpol, with a view to presenting charges under the Proceeds of Crime and Money Laundering Act. Program alone is not enough to keep the star witness safe. He concluded on the denial of bond at the stage when the accused has taken plea. The apprehension by the OTPP in the matter. On this basis, the judge found a compelling reason. On this basis, the judge found this is a compelling reason to deny. Mr. Mulama referenced our case in this decision from the Nigeria Supreme Court with the reasons to deny at page 3. The case of Republic versus Loni Mutia, number 11 of 2017, is also cited. It is also another case that deals with the issue of bail after an accused person has taken plea. The issue in the ruling is that the accused demonstrated in his behavior that he is a righteous, and for this reason the court rejected his application to be released on bail bond. The third and fourth cases are decisions touching from the first accused from a case that was concluded in the magistrate's court. He was found guilty and sentenced. However, the High Court quashed both his conviction and sentence. Mr. Mulama informed the court that he faced the antecedents of the first respondent. Mr. Galani court holds the arguments made by the prosecution. She said the seriousness of the offense and the weight of the evidence presented. Ms. Galani argued that the state failed to disclose that Feisal is not a convict because his conviction and sentence were quashed by intelligence information into evidence for presentation in court. In terms of the law, Ms. Galani argued that the Chumba versus Republic in 2020 JKIA Law. She argued that her clients are not flight risks and urged the court to impose restrictions and release her clients. She informed the court that Feisal is 58 years old and a diabetic 95 years old. Ms. Galani relied on Feisal Mohamed Ali, in which the High Court quashed the conviction and sentence from the Magistrate's Court. She also relied on Detention. The state will present Feisal and Mohammed as soon as they complete investigations, even if this is before the 10 days lapse. He reiterated that the request for 10 days is the least restrictive measure. Mr. Mulama added that Feisal and Mohammed have been treated with dignity to date, having been flown from Mombasa to Nairobi. He asked the court to consider that the witness protection program is not sufficient to protect the witness. I have listened to Mr. Mulama and Mr. Galani. I have also read the notice of motion and supporting affidavit signed by Corporal Anthony Bao, both dated August 27, 2025. Additionally, I have considered the authorities. The starting point for this court, as always, is Article 49(1), and in this matter, the relevant paragraphs are F, G, and H. Both Feisal and Mohammed are arrested persons. They have not yet been charged. Nevertheless, the possible charges are stated in the notice of motion and the supporting affidavit. The possible charges touch on wildlife crimes and possibly economic crimes. With regard to the authority cited by the prosecution, this court upon to consider the issue of pretrial detention. Kokumbao in his affidavit has explained that he needs to conclude the investigation, and this is in paragraph 7. He needs to conclude the following: A, DNA forensic cooperation, for example with Interpol. E, conduct financial investigations. In Betty Jemtai Kemewa versus Republic, Justice Moredi held that it was wrong for taking witness statements, obtaining call data on the applicant's phone. Report on the cybercrime aspects of the case are all things that could have been accomplished, all being out of custody. Justice Moredi also addressed what this court is grappling with, the 24-hour rule upon arrest. He said Article 49(1), G and H of the Constitution is complied with, then the rights are upheld. H and G itself gives, and I quote from the judge, Article 49, G and H itself gives scenarios on presentation of an accused person before the court, reasonable conditions pending charge or trial, unless there are compelling reasons not to be released, so that upon being brought presentation for assessment of fitness to plead before plea is taken, or he may be released if the court, for example, found no reasonable grounds authorities in contravention of the cardinal principles of the criminal process or fair immediate arrest of the suspect to prevent further crime, or to protect the evidence or witnesses. And the nature of serious crime require more time to investigate. In the face of the 24-hour rule requirement, the prudent thing to do is to delay the arrest until the investigation is complete and all prosecution evidence has been collected. Emphasis 9. Except where the suspect is a flight risk or likely to escape, or other risk to the successful prosecution of the offense, such as interference with evidence or witnesses, exists. The exceptions stated above is highlighted in the ground. Exceptions are on all fours the basis of this affidavit. The court now turns to the case of Sudi Oscar Kichumba versus the Republic, developed a two-step test in determining whether a pre-charge detention was indeed necessary. In the case before him, the trial court granted an application to hold the applicant for 7 days. Justice Professor John overturned the decision in his well-reasoned ruling. In doing so, he laid the test for such as the one brought before this court. He said, and I quote, at paragraph 24, so even while accepting the text of Article 49(1)(f) may, in certain circumstances and contexts, comprehend a situation where a person is presented before a court without being formally charged and is thereby state's application to have him so held, the state must satisfy a double test. A. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. B. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests present in a potential criminal trial: the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interests of victims of crime where appropriate. By virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by this quadruple interest and without verifying or essentializing any. Applying the test above to the facts presented in this application before me, I find as follows. On the first part of the test, there are exceptional circumstances which were argued by Mr. Mulama, and the fact that wildlife crimes touch on transnational organized crime. It is indeed true that the application is at its preliminary stage, but the reference to the wildlife trophy, which is an alleged, yet to be proved rhino, its weight of 2.2 kilos, the value of 10 million shillings, and reference to international syndicates are sufficient reasons for the court to pause and reflect on the need to grant time to enable the completion of investigations. On the second part of the test, which is balancing the rights of the individual, public interest, order and security, the need to preserve the dignity and administration of justice, and the interests of the victim, the court holds as follows. Article 49(1)(g) of the Constitution addresses the situation Feisal and Mohamed find themselves in their first presentation to court. It is prudent to reproduce Articles 49(f) and (g), which I have reproduced below. Lady Justice Njoki considered a matter on appeal before her regarding Article 49(1)(g) of the Constitution, and a decision made in the magistrate and 6 others versus Republic. That was a matter that came up before Lady Justice Njoki Mwangi in the Mombasa High Court. The applicants were aggrieved despite the fact that the trial court found they were charged. The trial court ordered for their further detention for 10 days. This was based on an affidavit presented by the investigating officer that they were on their devices. This was to establish if the applicants had been involved in the decision and moved to the High Court. Lady Justice Njoki Mwangi had this to say in her ruling, and I quote, "Court appearance to be charged or informed of the reasons for his or her or to be released. This court has herebefore restated applicants were informed of the reasons as to why they were arrested and the need for their continued detention pending investigations. It is the finding of this court that the Honourable Magistrate, by granting the prayer for continued detention of the applicants, acted within the confines of the Constitution." In Betty Jemutai versus Republic, Moredi J stated as follows on the interpretation of the provisions, and she quotes him. She then goes on to say, all that I quoted in the past, to say, I find the foregoing decision persuasive and applicable to the facts herein, as Sergeant Moses Mabenge, the investigating officer, appeared before the lower court and gave a probable cause for arresting the applicants. It is my finding, therefore, that the Honourable Magistrate exercised her discretion judiciously by making orders for the detention of the applicants for 10 days pending investigation. Lady Justice Njoki Mwangi dismissed the application. Similarly, the late Justice Louis Onguto presided over a matter touching on continued detention as brought under Article 49(1)(g). This was a constitutional petition filed with regard to petitioners that were infamously referred to as Pangani 6. That was in Johnson, Mudama, and 8 others versus the Inspector General of Police and 2 others. Justice Mbuto summarized the facts as follows. Number 1, and I quote, the petitioners, save for the 6th, are all members of Parliament. The first petitioner is a senator, whilst the others are members of the National Assembly. They all face the prospect of being charged with the offence of incitement to violence. They have appeared in court before a trial magistrate. That was on 14th of June 2016. They were, however, not charged with any offences. The purpose of the appearance was to ensure that the provisions of Article 49, 1F of the Constitution were observed. Following their court appearance, the DPP applied to have all the petitioners, save the 6 who did not make an appearance, still kept in detention. The trial magistrate agreed with the DPP, notwithstanding the valiant attempts by the petitioners' counsel to have the petitioners released on 14 June 2016. In the meantime, the petitioners felt aggrieved. They violated their constitutional rights. It was illegal. It was unwarranted. They were honourable members of Parliament, and continued denial of their liberty was wrong. Quickly, they moved to the court on 15th June 2016, and I had the application to be released on bond or bail under Article 49, pending their being charged in court with the specific offences. Justice Mbuto considered the rival arguments made by the petitioners' advocates and respondent by the ODPP. He reached the following conclusion and made a decision as seen in the excerpt below. I continue to quote. In the instant case, the bail sought before the Chief Magistrate was pending the arrested persons being charged. The petitioners have, through their applications, also urged me to grant them bail pending their formal arraignment in court to face charges. The DPP sought 4 days. The DPP advanced 2 reasons. Firstly, that the petitioners were likely to interfere with the witnesses. And secondly, that was the ground that there was need for additional time to finalize investigations. The affidavit in support of the DPP's application was sworn by Gilbert Kitalia. It detailed the circumstances leading to the petitioner's arrest, as well as the need for their continued detention. The DPP still argues that the reasons were valid and genuine, and they still are. The Magistrates' Court agreed with the DPP, but only to an extent. It granted the DPP not an additional 4 days, but 2 working days, and set the matter for mention on 17th of June 2016. The Chief Magistrates' Court came under attack before me by the petitioner's counsel, who asked for the release of the petitioners, but was defended by the DPP, who in turn sought to have their petitioners in custody. Both parties asked me to favour them with my discretion. I would first point out that the decision on whether or not to grant bail, in my view, is not a matter of discretion which implies a choice between 2 or more equal and proper causes. It is a matter of judgment as to whether the departure from the right to bail, which is the norm, is justified in any instance where it is opposed. My considered judgment in this case leads me to conclude that bail was rightfully denied, and the continued detention of the petitioners correctly allowed them, given the totality of the circumstances and the facts of the case. The limited time granted would also vindicate any decision to deny bail. The circumstances are exceptional. The petitioners face they may not be a flight risk, but certainly their influence in society is not to be ignored or gainsaid. A threat to witnesses and witness interference, as well as it must always be taken in the context of each case. Herein it is pretty clear that the petitioners are accused of conduct which threatens the national fabric. Petitioners in their own way have access to thousands of Kenyans. They are politicians, or so-called, when they speak or walk with thousands. Appropriate to have them confined as the DPP wraps up the formal process of charging them. The time for confinement is also to be limited to help equalize the petitioner's rights. Balancing the petitioner's individual interests with hearing rests one instance where the individual interest has to temporarily take a back seat, and let the public interest, which is to ensure that the DPP is assisted in his endeavors. But yet again, it is the Constitution which permits that liberty to be taken away, even if temporarily, if there are compelling reasons. Continued detention of the petitioners. It appears plain to me that in the circumstances of this case, and given the nature of the charges the DPP intends to pursue, it was desirable, and still is desirable, in the course of administration of justice and the public interest, limited time available, to enable all appropriate reports and investigations, even an appearance of interference. I would not intervene by granting any bail. I deny the petitioners their request. Of June 17, 2016, and renew their bail application. The application stands dismissed with no other upheld the decision of the Chief Magistrate to deny the 6 respondents, to detain the 6 respondents for 2 days. The prosecution had persuaded by the decisions of the Justice Njoki Mwangi and the late Justice Songuto. This court holds until proven guilty remains inviolable. With regard to public interest, order, and security, as well as the need to preserve the integrity of the administration of justice, this court holds as follows. Wildlife cases such as these attract interest not because of the respondents in the case, but the fact that the alleged rhino home, for the alleged rhino home to be away from the rhino means that a rhino died. It is as simple as that, and this is one of the factors that causes public interest. The supposed weight and value are an indicator that not anyone can make a demand for a rhino horn. This requires someone ultra-rich with a fetish for a wildlife trophy, and more often than not, these characteristics that drive the rhino horn demand are outside the borders of Kenya, hence the reference to international networks. In the reading of the provisions as stated in Article 49(1)(g) of the Constitution, it may be inferred that the framers of the Constitution intended to stem the tide seen in the Independence Constitution. This was a trend that people would be arrested, detained for unspecified periods of time by the state without knowing where or why. Under the Constitution 2010, the state is obliged to move the court and explain its justification for continued pretrial detention. The difference is night and day, and hence the application such as this one before this court, seeking further detention with the reasons given. In the matter before me, the applicant seeks 10 days. In view of all the above, I find it fit to grant 10 days. Since prior to on the forensics examination of the gadgets to be proposed by respondents, I grant it. This is the determination of the court. 1. That this honorable court be and is hereby pleased to issue the extended custodial orders authorizing the detention of the respondents herein for a period of 10 days at Langata Police Station, pending the completion of the investigation into the serious economic crimes and that of dealing with wildlife trophies, specifically rhino horns, contrary to Section 92.2 and 92.4 of the Wildlife Conservation and Management Act. B, that the Honorable Court be and hereby makes an order authorizing the investigating officer, co-compiled to forensically examine the electronic gadgets, the techno, and the Infinix. C, the OCS Langata Police Station is to ensure that the respondents have reasonable access to any medication required to manage illness, if all are necessary, to see that the respondents are escorted to a government medical facility for treatment. That there be no orders of costs. The matter will be mentioned to confirm compliance and or any other orders on September 9th, 2025. It is so ordered. Thank you. I'm about to give you a copy, just a minute. Please.
Your Honor, if I may please you, we are most obliged with your ruling, but are we counting 10 days from today?
That's what I count physically. So I'm assuming to be.
And then we have the matter of the I hold.
Yes, just a minute. You are able to
the state was not even willing.
I have some titles. Do you mind?
Not at all. Not at all, Your Honor.
Okay. That's my titles too. Oh, then you have to allow me to edit. It will take long. I'll do it just when I finish. Let's discuss these ideas. Surely, what is going on? Make your application.
It's quite simple, Your Honor. My clients require
Both of them.
both of them. require their IDs to be returned. Yes, they're incapable of doing any transactions, or for that matter, deputizing members of their families and other representatives from doing anything, including, as I said, bank transactions, collecting medication that is prescribed and that can only be issued to the prescribed individuals unless by production of ID. If Your Honor will permit me, perhaps let me not jump the gun and do a rejoinder before I know why the state is holding. So I'll hold. But ideally, I would like to close my submission by saying that there are no reasonable grounds that would require them to hold on to the originals of their IDs, considering the machinery of the state can get any information in relation to the accused persons. It is our view that it is a punitive measure, and we would pray that the court does order the release of their IDs.
Yes, Your Honor, thank you. First and foremost, Your Honor, I have to say that organized crime, Your Honor, are usually carried out by. Secondly, Your Honor, it is completely untrue that the state is unwilling and was even unwilling yesterday to entertain the defense. She was in our office. We went as far as explaining that she doesn't want to jump the gun and tell you for not issuing these IDs. That is because it is information she got from our office. Now, Your Honor, the reason we are apprehensive of issuing these IDs now, those IDs are subject to investigation. They are part of the investigations that we say are currently ongoing. Your Honor, yesterday my colleague presented to you a criminal appeal case involving the first respondent. And the details in that particular file, in that case, Your Honor, the name of the first respondent is spelled as Feisal. Your Honor, that particular judgment was delivered on 3rd of August 2018. That is a fact. You have that authority, Your Honor. Your Honor, a look at the ID that was recovered from that same first respondent, Your Honor. The date of issue is 2nd October 2018. And the first name is now spelled Feiswal. While that might look like a very minor change in a name, it carries significant value. And therefore, Your Honor, it is part of the reason that we are saying we want these IDs together with the second respondent. Because when I began, I said organized crime are done in a coordinated manner. We want these IDs to be forwarded to the National Registration Bureau to verify. It is merely for verification, Your Honor. And we cannot issue the very document we are suspicious about to the respondents, yet we want them to be subjected to investigation. Because in the event we find that there is a criminal component there, Your Honor, it will become an exhibit. So we are unwilling at this stage now to hand them over. And lastly, if counsel was a beneficiary of this court in the past, she would know that the prosecution has always returned IDs to all suspects who are brought before this court. We are not saying we don't want to give them. We are saying, give us time. Let us conclude the investigation and we will be able to give you those IDs once that whole issue has been cleared. That is all, Your Honor.
Now,
Okay, things that you were saying before we move on.
Yes. In brief rejoinder, Your Honor, while it is true that indeed I did go to the office of the DPP, the only response that I received is that they were pursuing a line of investigation. I first raised this with Mr. Mulama. Who simply said, we are apprehensive about releasing the IDs with no response. So there was no possible discussion that we could have because, of course, he was also coming to this court. When I approached my learned colleague, would not disclose what the line of investigation was, as he has openly done before you. Now, noting that they were not willing to do so, I raised the information that my client was given by the prosecution or by the state, that the reason the ID is being held is for the same reason that my learned colleague has put before you about the letter W that is in his ID. And I put it to you, Your Honor, as I put it to my colleague there. If in the previous matter they made an error in the name of the accused person, why is the prosecution not willing to hear us out? The reason I said that they were not willing to have a conversation is that my client, in fact, supplied me with documents to demonstrate that it was really a typographical error made by the DPP in that case you're being referred to. I also raised the question of how long then, because we could have been reasonable and come to you today without asking if they would give us an indication of how long do you plan to. That is not clear to anybody at this time. But what my learned colleague wants to tell you is that I think that since there is a problem with this name, then it's possible there's also a problem with the second respondent's ID. And that is the basis for also holding the second respondent's ID. That is the very definition of a fishing expedition. And so if Your Honor would be minded to allow them, and I say this without prejudice to my previous submissions, to continue holding the ID, we pray that you consider one, any form of verification, as I attempted to advise my colleague, can be done with a copy of an ID. Even with just the ID number. That's the kind of clout that the government of Kenya holds. And second, if you are minded to do so, the time should be very limited. Because even his access to a legal representative of his choosing is dependent on his access to his ID. That's all, Your Honor.
I have considered the rival submission to me. I find it fit to make the following orders. One, in view of the fact that the investigations are ongoing, the IDs for R1 and R2 will not be returned at this stage. However, in the interest of justice, the ODPP shall provide on our client's behalf. This is to be done before COB today. This has to be minded. I.e., because I
Does that apply to both respondents?
Yes, both of them. I said both. Certified copy of the IDs. Yes.
Thank you very much.
So, you see your mic. Give me 10 minutes. Alright. Give me 10 minutes. Literally 10 minutes. Naomba kuna watu who must go to investigate. So we have it.
Yes.
Let's deal with the one for the other guy now. So give me 15 minutes, 5 minutes, and then another 2. Do we have the assertive? That is his brother who was shouting. He needs to come and collect it.